Hello, everyone, and thank you for joining us today for this webinar intended to answer the frequently asked question, Loper Bright, has the demise of Chevron deference mattered? That is not a rhetorical question, and as our distinguished panelists will discuss, it has mattered a great deal, particularly in the TSCA context. And since the decision was rendered by the Supreme Court roughly a year ago, we thought it would be timely to take the question and really analyze it in the context of TSCA issues, because there's an awful lot of TSCA litigation going on right now. I'm Lynn Bergeson, managing partner of Bergeson Campbell, and I'm thrilled to be your moderator today. We have two presenters, no better presenters suited to discuss this really important topic. Leading off the discussion is Kelly Garson. Kelly is a senior associate with Bergeson Campbell and deeply engaged in a number of pending and ongoing TSCA litigations. Her practice focuses on TSCA and FIFRA and other global chemical regulatory governance systems. Following Kelly's presentation, Jim Aidala, BNC's senior government affairs consultant, will share his insights, as only Jim can do. Jim's extensive legislative background during his distinguished career in both TSCA and FIFRA matters, and also his role as a former assistant administrator for the EPA Toxics Division, in our view, makes him uniquely well-suited to comment on how EPA may be responding to Loper Bright in the context of rulemaking decisions and TSCA and other litigation strategies. Full bios are in the background section of your portal there, including bios, of course, a copy of the slides, which presumably you have already received, and a very helpful resource document. And I want to call to your attention, in the resource document, Kelly and I did a podcast on Loper Bright. So supplementing the remarks that Kelly offers today, along with Jim, you may wish to listen up to that. As usual, your mics are muted, but you do have the option of putting questions into the Q&A portal. We have a lot of questions that were teed up before today's webinar. We always try to answer questions in the moment, but to the extent we are unable to answer those questions, we prepare written responses to questions, and we will get those out along with the transcript of the audio proceeding. As for the agenda, we're going to talk, Kelly's going to kick things off, as I said, talk about the relevance of deference, what it means, then talk about the Loper Bright decision and the demise of Chevron deference, then move into what the impacts of Loper Bright have been and are and will be expected to see down the road with regard to current litigation challenging EPA actions, and then finally talk a little bit about what's next, both in terms of federal rulemaking and, of course, judicial decisions and congressional acts. So with that, Kelly, I'm going to turn it over to you to get things started. Thanks, everybody.
Great. Thank you, Lynn. So the attention and scrutiny regarding the overturn or demise of Chevron at the hands of the Supreme Court's June 2024 decision in Loper Bright is due to the controversial doctrine of Chevron deference. Deference is part of the checks and balance system that ties in principles of separation of powers in administrative law. As an action flows through the three branches of the federal government, deference is used to decide whether an agency action is lawful, often resulting in a tug of war between the expertise of agencies on the statutes they administer and the expertise of courts in interpreting the law. The Supreme Court has long grappled with how to proceed when the lines between executing and adjudicating become blurred. So after Congress delegates authority to an agency to act with the force of law, the agency decides what it must do and what it can do under the statute. When an action is slated for judicial review, courts must decide what Congress required, what the Constitution requires, and how much weight, controlling or persuasive, it must give to the agency's decision. So deference is not just relevant to people who are planning to or currently suing the federal government. The question of would this hold up in court plays an important role throughout the decision-making process. How a court is expected to respond and how it actually responds to that question can send a shockwave through the regulatory process, potentially sending a decision back not only to the agency, but to Congress to clarify its intent. In most cases, there's a single shockwave potential. Chevron was an unwitting earthquake. So what was Chevron deference? Chevron responded to a significant question of when an agency and a reviewing court have differing interpretations of an unclear or ambiguous statute whose interpretation should prevail. So the Chevron case was decided in 1984 and concerned EPA's decision to allow states to treat all pollution-emitting devices within the same industrial grouping as encased within a single bubble under the Clean Air Act. So whether the bubble concept was allowed or not, Congress didn't say. So EPA said yes, and the U.S. Court of Appeals said no. So when it was the Supreme Court's turn to decide, the court decided to defer to EPA's best judgment in how to carry out the act. What emerged from the court's answer was a process known as the Chevron two-step. So the Chevron two-step outlined a two-part analysis. First, the court was to determine whether Congress had already spoken to the precise question at issue, or whether the statute was clear, or whether the statute is silent or ambiguous on the issue. If it's clear, the court must effectuate the Congress's clear intent. If silent or ambiguous, the court is required to acquiesce to an agency decision so long as the agency decision was reasonable or permissible under the statute. It was required to defer to the agency whether it believed to be the best interpretation of the statute or not. So over the course of 40 years, Chevron was a governing standard in administrative law. But to measure the impact of Chevron's absence, it's important to evaluate the true influence of Chevron towards the end. So what are some of the factors that are helpful to understanding Chevron before and after? So first, Chevron deference applied in specific circumstances where an agency was interpreting a statute it administers, such as EPA interpreting the Toxic Substances Control Act, or TSCA. Other limitations were also placed on Chevron over time. So this included the subtle creation of Chevron Step 0, which would limit Chevron deference to agency questions that carried the force of law, as well as the major questions doctrine. Last, even among circuit courts, the application of Chevron was increasingly considered as unworkable under the framework, with variations in how the steps were applied or if they were even applied. In sum, the Supreme Court hadn't cited to Chevron since 2016. So originally meant to provide an answer if only on EPA's Clean Air Act bubble concept, Chevron ultimately led to more questions than answers. Since 1984, a mountain of literature has been written on Chevron with a litany of reasons both for and against maintaining or eliminating it. Over the course of its 40-year reign, the Supreme Court ultimately found that these major questions and concerns did not foster meaningful reliance. But as noted, the question of will this hold up in court reaches beyond parties that are on the cusp of litigation. Some argue that Chevron had created the flexibility for an agency to change its mind, noting that as the initial 1984 decision read, an initial agency interpretation is not instantly carved in stone, and that instead informed rulemaking requires consideration of varying interpretations and the wisdom of its policy on a continuing basis. Some may argue that the demise of Chevron has caused a subtle change in the type of questions that will be asked by both agencies and stakeholders when developing advocacy positions. Agencies such as EPA had to make sure their decisions were reasonable under the statute. Now they must ensure that their decision is the best possible reading of the statute. So turning to Loper, in June 2024, the long-anticipated decision in Loper Bright officially overturned Chevron. Loper concerned whether the Magnuson-Stevens Act, or the MSA, authorized a requirement for operators of Atlantic herring fishing vessels to pay for third-party observers. The MSA had authorized 3 other vessel-specific funding programs, but was silent on the question of observer funding requirements for Atlantic herring fishermen. The decision was challenged under the APA and was upheld by both the DC Circuit and the First Circuit as reasonable under Chevron. So when the case reached the Supreme Court, Loper held that it is the constitutional role of the judicial branch to say what the law is. Chevron had thereby prevented judges from judging. As decided by Congress, the court held that the APA requires the reviewing court to decide all relevant questions of law and interpret both constitutional and statutory provisions. In recalibrating the role of the agency and the court under Loper, courts must use their independent judgment to determine the best reading of an ambiguous statute. So in looking at how this could be applied going forward, unlike Chevron, Loper Bright did not create a clear multi-step framework for courts to apply. While only 1 year out, it is too soon to fully understand how Loper will be applied. So far, a series of questions has emerged. So first, the court might ask whether the best reading of the statute is that Congress delegated interpretive authority to the agency. If not, the court must then determine what is the best reading of the statute using all tools of statutory construction. The court will then determine whether the agency complied with its own interpretation or whether the agency or the petitioner's interpretation adhered to the best interpretation of the statute. So how do Chevron and Loper matter to TSCA? Several cases had been decided by applying a Chevron framework under TSCA. So, for example, in determining how the definition of conditions of use would apply under TSCA Section 6, the standard for prescribing testing under TSCA Section 4A1, and interpretations of Congress's requirements under TSCA Sections 8 and 14. These each included matters of statutory interpretation that the court held as warranting Chevron deference. So, for example, in the CMA case, the court upheld EPA's interpretation that it needed a more than theoretical basis to support testing as permissible, noting that the court did not need to determine whether CMA's interpretation was also permissible. In Safer Chemicals, Healthy Families, the Ninth Circuit reviewed EPA's first risk evaluation procedures rule and its definition of conditions of use pertaining to legacy activities. TSCA was clear that legacy uses and associated disposals required deference as they were. I'll circle back then. TSCA was clear that legacy uses and associated disposals were required under TSCA. Therefore, EPA's interpretations that those could be excluded was not lawful and didn't warrant deference. TSCA was ambiguous regarding legacy disposals, however. Therefore, the court upheld that EPA's decision to exclude evaluation of legacy disposals could be upheld. In EDF v. EPA, the DC Circuit reviewed EPA's interpretation of TSCA codified in its 2017 TSCA Inventory Notification Inactive requirements. For the clear statutory provisions, such as the requirement to include substantiation questions regarding reverse engineering, EPA's decision to exclude them was lawful under a clear reading of the statute. But TSCA was silent on which parties could maintain an existing claim of confidentiality. Therefore, EPA's decision to exclude export-only chemicals from notification requirements, that was an issue that Congress left open to EPA's expertise. The court held that these issues were reasonable interpretations of TSCA and were upheld. So with these cases as examples, a question for TSCA stakeholders now is whether of these cases would have been decided differently without Chevron deference. In the cases above, where the court found the statute was not clear, it vacated EPA's interpretations. This likely wouldn't change. But where Chevron deference did apply under Step 2, the court upheld them. This was a generally recognized outcome in the application of Chevron across different cases. Legal scholarship had observed that if a case was decided under Step 1, the agency was less likely to prevail, so this was considered the most critical litigation battleground. If the case was decided under Step 2, agency interpretations were much more likely to prevail. It is possible that if a court was required to look again, it would still decide that these cases represented the best interpretations of the statute. But it is certain that two certain key points would not be repeated under Loper. That is, the court's view that it didn't need to review the interpretation set forth by the petitioner, and that the court cannot solely determine that EPA's interpretation was permissible and defer to that interpretation. So looking at cases that have already involved Loper Bright, in December 2024, the DC Circuit decided one of the first TSCA cases under Loper Bright. In a consolidated challenge to EPA's 2023 CBI rule, the court denied petitioner EDF's petition for review while granting American Chemistry Council's petition. In that case, the court upheld EPA's regulatory definition of health and safety study under TSCA Section 14 as permissible, noting that it struck a balance between protecting trade secrets and broadening public access to data and analysis regarding the chemical's effects. The DC Circuit had applied a three-part analysis under Loper to discern the best reading of the statute and consistency with that reading, similar to some of the patterns identified earlier on. But for the provisions of the rule that were vacated as unlawful, including the requirement that would allow a downstream entity to potentially waive confidentiality for a specific chemical identity, EPA didn't conduct the same analysis. So though the court decided this issue on statutory grounds as well, it appears that the DC Circuit did not apply the Loper best reading framework, perhaps because it viewed the statute as clear instead of ambiguous. So it's possible this case will be a helpful example in determining how the DC Circuit might apply Loper in the future. On the whole, however, Chevron was only one piece of the administrative law pie. A TSCA case can raise a variety of questions in addition to statutory interpretations. These are decided under a different standard of review or a different deference doctrine depending on the specific type of decision. So TSCA Section 19 specifies its own standard of review, and that EPA's rule must be supported by substantial evidence, for example. So ultimately, there's a sliding scale, so to speak, of issues where the court is highly deferential to the agency and issues where the court will not afford deference at all. And this will continue to carry forward through future TSCA cases. So in terms of what's next, the Loper Bright decision is one of many cases in a fluid administrative law landscape. So the Supreme Court has decided several other significant administrative law cases in 2024 and 2025. So Loper and a corner post case, those cases made clear that resolution of statutory ambiguity was not policymaking and that agency interpretations may inform but not supersede the court, as well as that a plaintiff's 6-year clock to sue an agency under the APA begins when the injury is suffered, not when the action is final. So both of these cases appeared to expand the reach of the judicial branch. But in contrast to 2025 cases in CASA and 7 counties, these prescribe limits on the court's reach, emphasizing the role of Congress when drafting statutes and in granting or limiting the court's authority and requirements to defer to agencies. There are other major changes that may also be on the horizon. So one of the most significant could be an indication from the Supreme Court that it's willing to re-examine whether the APA authorizes the concept of universal vacatur, or where a court can hold unlawful an agency action, not just as applied to the parties in the case, but nationwide under the Administrative Procedures Act. Others have raised questions about whether past decisions under Chevron are now vulnerable to review, which are further amplified by the corner post decision. But even for cases where an EPA interpretation was upheld as permissible, even without an analysis as to whether that decision was the best, the door potentially opened by Loper may often require EPA to revise or amend an action that is subject to judicial review under TSCA Section 19 before it's eligible to be reconsidered under Loper Bright. So what's next for TSCA litigation? So for current and future TSCA litigation, it's too soon to determine how Loper Bright could impact the outcome of these cases. But depending on the room you're in, it certainly could be fun to speculate. So TSCA has engendered a significant amount of litigation in recent years. This includes litigation under TSCA sections 4, 5, 6, and 8, and 14. So the change from Chevron to Loper does make an impact, though how severe an impact is still unclear. One hypothetical is that if there's 4 possible reasonable interpretations of TSCA, or 3 possible interpretations A, B, and C, EPA might favor A, the petitioner, such as an environmental industry advocacy group, could favor B, and the court might favor C as the best reading of the statute. So under Chevron, the circuit court or the Court of Appeals would apply reasonable interpretation A in deference to EPA. But in the future, the court could still have the flexibility to switch to interpretations B or C. Now under Loper, if the court decides to apply interpretation C as the best reading, it raises a few questions as to whether or not the EPA has the flexibility to switch to A or B, or whether or not this raises the risk of circuit splits. So this issue may be of interest to TSCA stakeholders as it relates to the ongoing litigation saga under TSCA Section 6. So that includes EPA's Risk Management Framework Rule, as well as the several risk management rules EPA has issued in the past couple of years. So if you've been tracking this issue, one major issue has been whether or not EPA can issue multiple conditions of use specific determinations of risk, or whether it's required or permitted to issue one chemical-specific risk determination under TSCA. So if interpretation A, which is now EPA's preferred single risk determination, and B is the use-by-use risk determination, how could this be ultimately impact under Loper? So EPA's back and forth on this issue has represented considerable whiplash by stakeholders, and it's still been unresolved after 5 years. So EPA's 2017 framework rule initially appeared to contemplate either option, A or B, use by use, or one single determination. EPA's 2020 risk evaluations proceeded with use by use risk determinations. So this led to EPA's issuance of unreasonable risk determinations for chemical substances, which were all challenged in court under TSCA Section 19. In response to arguments raised in those cases, EPA then determined it could apply an A-B approach, stating that it was within its discretion to decide, as the case warranted, whether to issue a use by use or a whole chemical approach. Once EPA issued revised determinations in 2022, this led to the voluntary dismissal of those risk evaluation cases. But then in May 2024, about a month before Loper Bright, EPA issued a new final risk evaluation framework rule that codified the single determination approach, stating that EPA believes this reflects a plain reading of the statutory text, and issued risk management rules under that framework. So EPA was sued on the framework rule and its risk management rules for those same substances. So the framework rule litigation has now been held in abeyance after EPA announced again its intent to issue a new expedited framework rule by 2026, which could potentially switch back to interpretation B or the use-by-use approach. So even so, one risk management rule, the rule for methylene chloride, has proceeded in the first Fifth Circuit in the case East Fork Enterprises versus EPA. So if the Fifth Circuit reaches this issue in East Fork, this leaves open potential interpretation C. What does the Fifth Circuit view as the best reading of the statute? So in sum, concerns regarding accountability, flexibility, the potential for circuit splits, these issues and concerns were raised under the Chevron framework, but there still remain some significant questions. So if an agency does not proceed when it's issuing a rule, if it doesn't determine at the time that something's the best reading, but introduces a controversial policy that is permissible, but perhaps, arguably other interpretations could be better, and that's challenged in court, the court will decide for them what the best reading will be. So while this could lead to an increase in TSCA litigation, potential litigants also may wish to sue if they are confident that their argument sets forth the best reading of the statute. Otherwise, even they could be subject to an interpretation that's even less favorable than the one that the agency had originally set forth. So, warranted or unwarranted, agencies had a bit of protective armor under Chevron during a lawsuit. So if it could be certain that its interpretation was reasonable, it could move forward with an extreme interpretation, knowing that if it were challenged in court, it would likely succeed. So it seems, which could still be up to interpretation, that Loper took away that armor. In general, it encourages EPA to identify policies that will last across administrations as well as across courtrooms. So for impacts on stakeholders, this encourages parties that might be subject to potential policy changes to make sure that when they submit public comments to EPA, they're clear in setting forth that their policy interpretation represents the best interpretation with a careful review of Congress's mandate under TSCA, so that ultimately when the decision is issued and if it ends up in court, the party has a defensible position that their view represented the best reading and is likely to be upheld. So a final note on TSCA litigation before turning things over to Jim. EPA's framework under TSCA Section 6, as an example, resulted in multiple lawsuits at every stage. So the 2017 framework rule, EPA's 2020 no unreasonable risk determinations, EPA's 2024 risk management rule, and now it's 2024-2025 risk management rules. Once EPA is expected to issue its 2026 risk management rule, that's likely to result in another round of litigation. So perhaps this is just par for the course of an agency in trying to get a very complicated, very complex statutory framework right. But in sum, stakeholders will all agree that it is important for EPA to get its risk evaluations, its risk management rules done right, and to ensure that EPA reasonably, prudently, and effectively carries out the important provisions of TSCA aimed at protecting against unreasonable risk. So is Loper a potential answer? Perhaps the Fifth Circuit will begin to tell us when it issues a decision on the methylene chloride risk management rule. But for now, I will turn things over to Jim.
Okay, turn my mic on. Always a good thing. Hi. I'm going to take things a little bit in a different direction. Obviously, that's a tour of the Legal Beagle framework and looking at Kelly's slides about the pathway through all the various players. Is that a pathway, or is that the sort of Supreme Court two-step or line dancing around all the issues that come together about trying to interpret legislation? Excuse me. I'm going to talk about legislative crafting and things that are more in my wheelhouse, not as a not lawyer, in terms of all the particulars of the cases and things, but what's behind that curtain in terms of legislative crafting, because not everything can be part of the legislation. What a little bit of the reveal about agency decision making, having been in senior political position for the entire time of the Clinton administration. And then also, and just generally as an observer in many years, over decades of agency ability to craft rules and policies and interpretations. And that's the soup of things that then go to a court under review that then have to be interpreted in the ways we just heard about. So how big a difference will there be life, after Loper? Well, there will be a difference. Who knows what that will be? That's what we just heard about. But at the same time, there were rules and regulations before Chevron, and there will be rules and regulations after Loper. And so how all that process may play out is what what all of us are about to see in the next few years. Next slide, please. A little bit on legislative crafting. Obviously, it's too simple to say, but it's very true. It's a compromise between and among all kinds of interest groups, stakeholders, the affected regulatory community, other players. What's interesting is sometimes you might end up with an advocacy group or an interest group that you didn't expect to find along the way and to be interested. At the same time, one of the things that if it's really going to be an administration initiative or an administration endorsed piece of legislation, even towards the end of its gestation, you'll see all the other agencies of the government come into play. They'll start to say, well, the USDA is interested in pesticide law. Commerce Department might be interested in TSCA issues. What about those trade guys over at the Trade Representative's office? And then within the White House, you've got OSTP, you've got the Council on National Economic Council, you've got all kinds of other acronyms and people and players. Certainly for EPA, CEQ always has to try and figure out what they're going to do on their day off. And so they need to weigh in on things because they're representing, interests that are relevant. And so that's in addition to the committees of the House and Senate with the obvious legislatively relevant, players, the House and Senate committees of jurisdiction. But then again, even in the House, for example, the House Science Committee may want to play on an issue. For example, that's a place where Al Gore, as a young congressman, used to talk about climate change before almost anybody else in the House Science Committee, and then would raise those issues and something that may come up germane on the floor. And then, of course, the classic House versus Senate kind of jurisdictional and who's really in charge. Is it going to be a bounce bill? Accept my amendments. No, you accept mine. No, I don't like you. I don't like yours. Again, all that sausage making, as it's called, to get to a law. And the other thing that happens is that you do have often in legislative crafting very clearly what I call intentional vagueness. You don't want to try and resolve it in the legislation, partly because you couldn't come to agreement among all those stakeholders, but also because we don't have that technical expertise, speaking in that voice, for the moment, to get that fine-tuned, that detailed. So, for example, in the case of Food Quality Protection Act that I worked on quite a lot, to say the least, there's an issue. There's a very important issue there, which is how many people does it take to fill a risk cup? Next slide. And we're going to be talking about that risk cup later and the kind of vague issues where that comes into play. Meantime, again, there sometimes are clear directives. I happen to reconfirm, I believe it's only one page long and my camera there. Sorry, it's one page in the original TSCA legislation, which concerns PCBs, which then consumed agency work for quite a long time, an incredible amount of resources. And it seems to be very clear about what Congress thinks about PCBs. Control the ones in totally enclosed manner, phase down production, and eventually dispose of those products because we've determined that PCBs are a bad thing. Very clear, right, Congress? Well, then it turns out, years later, and even recently, in relatively recent years, there's still been an ongoing issue about exposures we didn't expect, places where it was used that no one knew at the time. And EPA has to deal with all of them. One good example there, notwithstanding clear directives, An example from my time at EPA was that there were PCBs in a defense being used in transformers and other things in a defense facility in Japan. By practice and things that had been agreed to procedures, that those would be transshipped to America for proper disposal. Even though they were located originally in Japan under American jurisdiction at a defense installation. Okay. Well, along the way, they stopped in Guam. Well, given the particulars that no one quite had seen ahead of time, whether Guam's a protectorate or a territory, and the kind of way that interaction with some international agreements about dealing with hazardous waste import, so-called import, and things like that. To make a long story short, the shipment of DoD PCB products were stuck in Guam and couldn't get out. They could get in, could be shipped in legally, could not get legally shipped out. So we had to write a rule. Okay, well, and it's, as many have said in other contexts, it's not easy to write a rule quickly for almost anything. And in particular, the delegate to Guam was quite concerned about having these PCB materials in Guam, potentially subject to big storm coming in, contamination and other such. And so we would get a daily call, literally a daily call from the delegate from Guam, because he was committed to that to his constituency. And I would hand it off to my deputy to take the call, because that's what deputies are for. And every day he would call and we would talk to him and saying that, oh, yes, we're working on the rule. Here's what its status is. And we're very concerned about it, too. We share the concern. And then eventually it did get done, thankfully, and the material got out of Guam. There's another unintended consequence or an altogether mistake. I used to do this offer a prize for a trivia contest, but find the words benefits to support family in FIFRA. And it actually is in there. If you go to the EPA website and say, what's the text of FIFRA, you'll see a copy of FIFRA. And in section 4, there's this phrase, benefits to support family, which is simply a vestigial tale from the person who drafted some of that language way back when in mid-90s that was working on the then welfare reform bill. And that was Energy and Commerce Committee staffer and had a leading role in helping do the Food and Drug amendments that became FQPA. So there's this phrase called benefits to support family, which is just sitting there and doesn't do anything in the good sense. But again, if you have the wrong words in the wrong place, sometimes it shall we say, may make a difference. And deadlines and other signals. Sometimes you would put deadlines and laws to be a signaling function. So, for example, endocrine disruptors, which is part of FQPA, go deal with pesticides as potential endocrine disruptors. The science staff at the office had said, there's no way we're going to do anything, even begin to get what tests are the appropriate ones, impose them on some appropriate part of the universe and get the data in and evaluate the question for at least 6 or 7 years. I said, politically, that's too long. This is supposed to be an important issue. How do we say, this is really, really important, but we'll get to it in 7 years? And they said, well, that's how long it's going to take. I said, well, I'll tell you what, we'll put 3 years in the statute. No, it's going to take 7. I understand. We're going to put 3 years in the statute. And it's still an ongoing issue to this day. So again, that's part of everything from signaling to there's various reasons you might put in deadlines, including that then if you get sued and have to agree to, being on some kind of court-imposed deadline in light of some deadline in the statute, that gives you more currency within the internal budgeting system of EPA or any agency. That then I have to meet this court deadline. I need more resources to do that. So sometimes you might even put in a deadline you're going to miss in order to know that that's going to help your budget and other kinds of things later on. Next slide, please. So again, sometimes clear language is there, but sometimes what appears to be clear language is not so clear at the end of the day, implementing it, number one, but sometimes it just overall needs to be operational because you have to, obviously what the agencies do is develop key terms and guidance. By regulation guidance, a lot of work is done by guidance and pesticides, more by regulation and TSCA. And again, at some point, and this is the overall question underneath everything Kelly and all these cases talk about, which is what's a reasonable choice versus an abuse of power. A current one, for example, too, that is clarified by clear language or clearer language, excuse me, would be in TSCA, the debate about personal protective equipment and whether risk assessment should include that. Well, in TSCA, there's a debate, and not trying to weigh in on it per se, but even if it's required to be done, or people can show by survey that PPE is worn, how that should be accounted for in the risk assessment. In pesticides, the law fortunately has this phrase called widespread and commonly recognized practices. It was actually put in to be more conservative at the time because you can't require to wear a very heavy waterproof, rubbery moon suit, if you will, to apply pesticides in the South in the middle of the summer. And so that would not be a widespread and commonly recognized practice. But if there is such a practice, you can include that as part of your presumptions in the risk assessment, number one. Number two, PPE is clearly something that can be put on the label. It's a program that was developed over years and been in place now for almost 40 years. Or 30 years plus, and then the PPE is part of the label, so it's going to have to be worn, and therefore we can assume PPE is worn. So another kind of clear language issue that came up, so-called, it's very clear in FQPA, a major pivot point, a major absolute foundation of that approach for pesticide regulation is that there's a reasonable certainty of no harm. That's the definition of safe in the Food and Drug Act. Next slide, please. So at the time when we were deciding what's that key phrase mean? Reasonable certainty of no harm. Well, we had choices developed. We had EPA does have a lot of details and things won't go into, but we know what people eat. We know what they eat by age, demographic group, ethnic group, other kinds of age groups, and all kinds of things that you can slice and dice data. We know what they eat, and we know the residues that would be expected to be found on those foodstuffs, so we can calculate an exposure distribution. And along with the hazard assessment that's done by all the data that come in on a pesticide, we can then say, okay, here is what the the risk is going to be. Where do you draw your line on that exposure distribution? You draw it at 90% of the population, 90% of the exposure expected in that distribution, or the numbers at 99 or 99.9. We chose 99.9, very conservative number. So in other words, any expectation of the residues for all these different demographic groups would be 99%, 99.9% or less. Very conservative, but it certainly would have been reasonable to say 99% of the time. It's not 99% of the people, it's 99% of the exposures. And so 99% of the time you'd be, making sure you're at or below a level, because even the hazard levels determined with safety factors and other kinds of things too, that would have been enough. If you had done 99 instead of 99.9, every risk cup under pesticides would be 10 times bigger. And so potentially all exposures to those products would be 10 times more than what they are now under the current practice, not the current law, because arguably that would have been a legitimate, reasonable interpretation of what reasonable certainty of no harm is. Next slide, please. Another concept from my time in government, not only at EPA, but even just being an observer and being on legislative oversight committees and other kinds of places, is what I call stretching and creeping. And what I mean by that is you stretch current authority to cover a situation that needs to be dealt with, but it may be novel, it may be new, it may be emerging, and it's something that wasn't envisioned when the authors in Congress were making that piece of legislation. So, for example, biotechnology. In 1989, there was the Bush senior administration created this thing called the Quail Council to be their attempt at regulatory deregulation, regulatory relief, and the Quail Council came out with a biotechnology framework about 1992, if I recall, and in that framework, the fundamental point of it was we don't need new laws, even though none of the laws at FDA, EPA, USDA had been written with biotechnology products in mind, that were still in late research stage. They had not been commercialized, but they were about to be. And so we don't need new laws to cover these issues. And that fit, and if you will, literally fit. But every now and then there's a kind of thing like research that's being done, and who knows what kind of research. Don't you want to know all this kind of weird biotechnology research that might be going on, quote unquote, weird, because it was novel. Okay. Well, most of that research is done by a company, and you have control over that as a regulator to some extent, or you can impose that. You have control over federal grants to universities and research institutions and things. And so, okay, we kind of know about that, but you wouldn't know about something that's going on in somebody's garage or someone doing something privately on their operation. Well, should you worry about that? Well, we don't think much of that's going on. Well, okay, but at the same time now, years later, as we speak, you can buy the latest iteration of emerging edge of biotechnology is CRISPR, so-called CRISPR gene editing. You can go on Amazon as we speak, and for $100 or so get a home CRISPR kit to manipulate genes. Okay, now is the government aware of all that research that's going on in somebody's garage? Most of the stuff from Amazon is not probably going to be too interesting, but who else is out there? What else is out there? And again, there was an affirmative desire at the time in 1990 or so, early 90s, to then not have new regulations, new laws that cover the what if scenarios, because it was unclear what all those what if scenarios may mean. So is that a stretch, trying to get that rubber suit over to cover these kinds of things? Or is it altogether unauthorized, or should have been more authorized, to be more clearly authorized? And those are the kind of things later that come into court. A mission creep. Quickly try and just say about TRI. There was a Bhopal incident in 1984. Horrible tragedy, thousands of people killed and injured. And so, okay, Congress puts in toxic release inventory right to know provisions. What's over the fence? What's going on in that chemical facility over there in my community? Very good. Well, then TRI is expanded. It's going to include mining and other kinds of industries. Okay, well, do you know what's really going on at a copper mine? Well, they use chemicals, so we need to know that. They might get into the water and things and downstream effects. And so, okay, TRI is added mining. At the same time, when I was at EPA, we were considering whether or not gas stations should be added to the TRI list of covered entities. And gas stations, if somebody has a gas station in their neighborhood, are they really unsure what's in the gas station? And we fought with OMB. We ended up losing that expansion option. But, you know, OMB was quite concerned that, well, hold it, there would be hundreds of thousands of new reporting entities. How much, and a lot of them are small operators and small businesses, those kind of issues with reporting burden and other kinds of things. And that was a real, you know, the basic fundamental question was, do people know it as a gas station? Most of it's gas. There's reasons why to put them on the TRI, but again, at the end of the day, that was not done. So again, is this rubber suiting and mission creep that somehow comes together and then, you know, eventually always expands the administrative state, expands the regulatory ambit of these agencies, because they got to look like they're doing something. And again, at some point, does that ratcheting effect of mission creep meets some kind of rubber suiting to then become a, quote, major question that the Supreme Court has weighed in, saying, well, at some point you get to the limit, and that becomes a question that only Congress can answer. Next slide, please. So life after Chevron. I'm sorry, I've got my wrong slide here. I didn't go to my own notes. Sorry about that. This is a little bit of a lighter note. So there's at the end of the day, like the example of 99.9% distribution of the exposure profile, you come to decision meetings at a place like EPA, any agency. And in my experience, you have basically four options that are presented to the decision maker. One is assume we have perfect information. We don't have that. Assume we have an infinite budget that can be, you know, used to do good things. Well, we don't have that. Here's the option we think you ought to pick, political appointee, because this is the way we've done things. This is the kind of way we've always approached this kind of issue. This is how we would apply all these practices and procedures and guidance to this issue. And then option 4 is, well, some of the ideas you had last time and why they won't work. Again, that's a little tongue in cheek, but in my time at EPA, I would start to say, oh, option 3. Today you're wanting us to pick option 3, right? Oh, okay. Oh, option 3 again. Look at that. And then say, well, maybe, and eventually they started changing that. What would appear to be the staff recommendation in strong terms was option 2 or option 1, and so on and so on. And that was a real example. And I used to call it "Where's Waldo?" And if you talk to some of the folks that were with me at EPA in those days, they'll know those terms. Anyway, next slide, please. So life after Chevron. So again, there were regulations and interpretations, policies, and all that. Those are not new ideas. There is agency behavior that I used to describe as trying to find stasis, bureaucratic stasis, if you will. Sometimes I might call that zone of indifference, not indifference of the staff to their mission, but just simply, can we find the place that most people leave us alone? When I say people, I mean the stakeholders, the courts, all the various constituencies. Not that being left alone is a sign of success as much as it means that you found the balance of these interests and all these dynamics you have in those jobs. And so if you look at the terms ecological stasis versus ecological perturbation, I looked this up. These are two models of evolution. And will Chevron then be some kind of major perturbation? It won't just be the next thing after, Skidmore meets Auer meets Chevron. We're snapping back with Loper, or will it just be a whole new thing, whole new world legally? And again, I'm not a lawyer, so I'll let the lawyers talk about that, as Kelly has done. And then at the same time, there's always going to be an issue where legislative terms and definitions are going to be subject to different views. So is the view of the bureaucracy with all that goes with it, the people, the staff, the guidance, the years of doing it a certain way, defining things a certain way, certain practices, is that more or less arbitrary than some judges saying, oh, I'm reading the law and I think it ought to be this nowadays? And again, that's just a rhetorical question that comes to mind listening to things about the opinion and what the speculation about the future may be. So next slide, please. So life after Chevron, is it going to be clearer or more muddled? Is it going to be whose views, whose beliefs, whose basis, what basis should prevail? Now, is it going to be the judges that are we going to go venue shopping more or venue shopping less? Will it be judges versus bureaucrats? And it's not binary. The real point is it's not binary. It's not like there's a clear answer here. It should be bureaucrats in deference to agencies. It should be judges who are reading best notion of their interpretation of what the law says. And that to me is the sort of life after Chevron, life after Loper kind of question that's going to now unfold over the next few years. Yeah. That's it for me. I think we're going to take questions. Thank you. And I think we turn back to Lynn.
Thank you, Jim and Kelly. Excellent presentations. We obviously cannot do justice to the complexity and intellectual issues that arise in the context of applying the Loper Bright decision to the many, many vexing questions that are, arise in the context of TSCA most, specifically, but also to your point, Jim, a lot of these issues come up in FIFRA as well. But let's, in the remaining 5-6 minutes that we have, there's a lot of questions. And again, we will not be able to get to all of them, but we will respond to all questions in writing. So just one quick question, point of clarification, Kelly, if you would respond to, you had noted in your remarks, what are circuit splits? If you can just, for the non-lawyers in the audience, define what that means.
Definitely. So a circuit split occurs when two circuits issue conflicting or differing interpretations or decisions. So for example, if a case is heard in the Second Circuit and it decides one thing, and the same issue is raised in the Ninth Circuit and it decides something different. So when that happens, agencies and stakeholders are somewhat left in limbo until either the Supreme Court or Congress intervenes to resolve the quote unquote circuit split. So with statutes like TSCA that impose national requirements, a circuit split could be very confusing. So, could EPA only enforce a policy in New York that it couldn't enforce in California? So resolving those is very important. Under TSCA, most of the time, lawsuits occur all at once. They're required to be filed under Section 19, within 60 days of a final action. So, and if multiple petitions are filed, they're often consolidated into one circuit. So it's possible for there to be circuit splits under TSCA, though maybe a little less likely than cases that arise under the APA across district courts. I'll note one solution for circuit splits is for Congress to require certain cases on environmental statutes or other federal statutes to only be heard in the DC circuit. That's one manner of trying to avoid a circuit split.
And Lynn, just for the record, circuit splits are different than what I call regulatory gymnastics when agencies consider all kinds of weird things to figure out a way to get to a final decision. But again, that's up there with the rubber suiting and the other things.
Right.
Anyway.
No, thank you both. All right. First substantive question. In addition to Loper Bright, one of our listeners is interested in understanding how cuts to federal resources, agency staffing that we've heard so much about since earlier in the year, both cuts and reductions in staff that have already happened and those that might be forthcoming. Is that likely to affect, and the question here, Kelly, specifically addresses Skidmore deference, or other ways courts recognize agencies' technical expertise? So Kelly, why don't you kick us off, and then Jim would like your views.
Sure. So Skidmore deference was a doctrine that preceded Chevron, and that noted that reviewing courts should consider several factors in determining whether or not an agency decision warranted respect, or whether it could be treated as persuasive or even under Skidmore even as binding at times. So that concerned factors such as whether the agency had put forward a decision that was consistent over time, the technical and scientific expertise behind the agency decision. I think in terms of Loper, a lot of the time, a lot of these very, the serious issues requiring EPA scientific expertise, those are largely, findings of fact or other types of agency determinations that are likely more, granular than an interpretation of, a requirement under TSCA itself, for example. So when the court ends up looking at, a finding of fact based upon EPA's expertise that falls under either the highly deferential standard to agency scientific findings, as well as, whether or not the decision is supported by substantial evidence. These issues could come into play, for example, when interpreting a statute. It's maybe a little more likely to come into play looking at, EPA's application of its interpretation rather than the interpretation itself.
Got it. Jim, any thoughts?
Well, yeah, I think it mostly just means more delay, just because agencies have to restaff. At the extreme, you could imagine where, because of staff cuts and inability to hire, say, the newest, latest, greatest expert in some element of some science issue that's underpins a regulation, that someone could claim EPA's regulation is whatever, ill thought out, or unreasonable or what have you. And look, dear court, EPA doesn't even have one biostatistician anymore, and this is a big statistical question underneath some issue. I think generally it just means delay, because the agencies are going to have to restaff, restock, train their people. All those are going to be a problem, even to the extent that, of course, people are frustrated, but the pace of work coming out of both programs, toxics and FIFRA, pesticides, right, that that decisions aren't getting made timely and so on and so forth. Getting severe cuts and new staff coming in and to be trained will not help things.
Since it's now 12 o'clock high here in Washington, we are technically out of time, even though we have just a ton of very, very interesting questions from our very smart registrant community. But I'm going to wrap it up there. Thank Kelly and Jim for really wonderful substantive presentations in a very difficult and fascinating area of the law. I would urge all of our participants to be mindful of the many resources that we offer free. We also will be sharing written responses to all of the questions that have been received, because as I said, a lot of them are really, really interesting, and I regret we didn't have time to get to them. But thank you for your interest. Thank you for joining us, and we hope you found this webinar helpful. Thank you.